Hey guys, we're back with our we're back with Moot, episode 2. You know what the agenda for Moot is, to help the first time mooters, how to go about their case. You guys also know that we're working on the ULC Alumni Association Moot, which is a case of Mr. Shivaji versus the state of Arunachalam. I think you guys are clear with the facts of the case. So here I am to just give you certain guidelines how to go about your case on behalf of the petitioners. Let me tell you, this is just basic research that we have done, and it might help you guys to work on your arguments and on your memorials. So we are talking about petitioners right now. So you guys might know that it's a case filed by Mrs. Shivaji, which is an SLP. So SLP is your case here. SLP is filed under Article 136 of the Constitution. So what does Article 136 state? It says where any person aggrieved by any judgment, decree, determination or order in any cause or matter passed by the court or a tribunal may appeal to the Supreme Court. And this is what basically it says. So it is, if you are aggrieved party, you have a right to appeal. So special leave also means you should have the permission of the High Court or the permission of the Supreme Court to appeal before it, to hear the case before the Supreme Court. So it's an appeal before the Supreme Court with the permission. Leave is the permission in this case. So it is coming to SLP, SLP has a time limit of 90 days to be filed for an appeal. So here, in this case, the petitioners have exceeded the time limit. They filed the case after the 8 months of the order. So what can you guys do here? The law is against you according to the Article 136. You've already missed out on time. So this question might be bugging you guys, whether the case is maintainable before the court. So I think the Limitation Act has come to your rescue in this case. Section 4, Section 5, Section 13 and Section 14 will help you in this case, especially Section 5 of the Limitation Act. You better read it. I think it's one of the key in this case. This will help you to crack the whip on behalf of the petitioner, and it is going to cost the arguments of the respondents. Coming to Srimati, to help you in this case, there's one case, Srimati Tej Kumari versus CTI. It's a 2001 case. The citation is 247 ITR 210. Full bench of Patna High Court held that when SLP is summarily rejected or dismissed under Article 136 of the Constitution, such dismissal does not lay down any law. The decision of the High Court against which SLP was dismissed in Lemeen would not operate as res judicata. However, when Supreme Court dismisses SLP with reason, it might be taken as affirmation of the High Court views on merits of the case. Thus, no reason to dilute the binding nature of precedents in such cases. So, on prima facie of this judgment, you might feel it's slightly towards the respondent, but if you read between the lines, I think it will help you for the petitioners. This is just a small tip. You can work on it. Then, generally, when it comes to the apex court, it will not grant special leaves unless it is shown exceptional in special circumstances exist that substantial grave injustice has been done in the case. So here, as a petitioner, I think you have to prove that it's grave injustice to dismiss the petition. Again, as a petitioner, it is up to how you will reason it out using your facts of the case and the circumstances of the case. When you talk about, and please connect the circumstances. Why did he try to remove the life support system? What was his condition, economic condition, and why, as the police has filed an FIR 309 of the IPC, why they think this is suicide. So why did he try to commit suicide? Don't ever try to hide the fact that he's tried to commit suicide. If you try to hide the fact that he's committed suicide, I think you're just losing your case. I think the court will just try to hammer you on that fact. Stick to the fact that he's tried to commit suicide. Then, okay, to help you, I think in the next issue of suicide is trying to take away your life. So it has to be somewhere related to Article 21. So next issue should be based on the Article 21. What does Article 21 really say? Article 21 says it deals with protection of life, personal liberty, where no person shall be deprived of his life or personal liberty except according to the procedure established by law. So it is a legal, a legal rule. So it's again how you interpret the maxim here. Coming to your case, he's tried to take away his life. Article 21. Does it give you the right to take away a life? The court might ask you. So try to reason it out, saying that why has he tried to take away his life in this case? And to save you from this thing, you have definition of life. What is definition of life? Definition of life clearly tells that a man's life has to be in certain way where it shouldn't be of a vegetative state and it should be more than animal existence. So try to connect this to your case. What was his case? What was the condition of Mr. Shivaji? Mr. Shivaji was suffering from bone cancer. The chemotherapy didn't work to him. His wife was working. His children were out of school, and it was the financial burden was mounting over him. So he was in deep agony, deep pain, and try to say in your case that if any reasonable person in Shivaji's place would do the same thing, I think I would have done the same thing. I can't see my children out of school. I can't see as if I was Shivaji, who's earning a lot of money through my patents, through my research, through my intellectual knowledge, and giving a wonderful living condition for my family. Basic everything was met. Shelter and good food, protection of life, everything, your life was in complete safe hands when I was working, if I was in Shivaji's place. So in this case, he's already in the hospital. He's almost, his condition is deteriorating, not improving, financial burdens. So you connect all these things in your case, and you can talk on the basis of Article 21. And when you're asking about Article 21, try to talk about saying he's trying to die, fine. So try to give him a decent death. It's a right, and it's a right of any person to have a decent death. So this is your main conclusion in the case. So you have to put it in chronological order in your case, where Article 21 you want to place, and where your jurisdiction. Put it in chronological order. Coming to the FIR, what is your main issue? Why have you filed the SLP? SLP has been filed to quash the FIR. So coming to the FIR issue. When you talk about FIR, FIR has been filed by police on the basis of media reports, on basis of media. It pleased the media and all that, and they've included the hospital as a party, they've made Shivaji as a party, and to quash the FIR, you've already gone to the High Court. High Court has rejected your plea. It was a writ petition. So don't worry if the High Court order is against you. So you have a right to appeal, and the Supreme Court is the apex court. So you have a right to appeal, and if you have a wonderful case, wonderful argument on behalf of your client, the verdict will be on your favor. You might feel the law is against you, but you should always have a point of view that it is always up to the court to prove. I can quote an example of Section 377 being quashed by the Delhi High Court. The law was any day against the petitioners, but it was quashed at the end of the day. So it is always, so look at the brighter side, my friends. Coming to the FIR again. So try to connect the intention of the FIR and the motive of FIR. What is the intention of FIR? It's a mere procedural aspect. It is in the law. Police have done their duty. What is the motive of the FIR? Motive is to bring people to justice. Be reasonable. Try not to take away your life. That's the main motive. Why, you might ask question, when you have the right to live, why don't you have the right to die? So I can say this is because the state has imbibed rights in you. The state has given you the rights. So that means you are having a duty towards the state. The state has invested on you. To give you a simple example, I think I can give you polio drops. Polio drops has been given freely by the government on every Sunday of every month. It's been advertised. Amitabh Bachchan, who says "Do boon zindagi ke." So that means how precious life is. Do boon zindagi ke. That shows the preciousness of life. So state has invested on you. It's free, but state has paid for it. That means the state has invested amount of money on you. So indirectly you have a duty towards the state. So this is coming to the motive of the FIR, or why you don't have the right to take away your life. And what is the ultimatum? Ultimatum is to punish the person who tries to take away your life, or take away his life, sorry. And in this case, if Mr. Shivaji has tried to take away his life, why? Why? Because of his conditions. You know the facts of the case. His condition was not good and all that. I don't have to explain it, I think, right now. You guys are very clear with that. So try to connect it with the intention and motive of the FIR. Try to give it a test of reasonableness. Is it reasonable to punish Shivaji in this case? As because he's tried to commit suicide. Try to give a test of reasonableness. Reason it out. Tell the court. Okay, fine. If you want to punish Mr. Shivaji, go ahead. But what is the use? He's already in his deathbed. He's in coma. There's 20% of chance of recovery to come back to his senses. If you punish him, he anyway has to stay in the hospital. So he's already living a secluded life, and the law also says you can't punish a person who's not in proper senses. He's already in coma. So what is the use of the case? This is your main point. Try to look into the law. There's law in the IPC. There's also in the Constitution. What is the this thing? Who can be punished for offences? So there is also one tip that I can give you at this moment of time. So if you connect all these things in your issue, I think the order of the court will be always on your side. These are the main important points. I think you guys would have also thought about it. This is just my view of case. And if you have any other points on the case, you can add. These are the basic things you need to work on. My friend Shiva will be back with the respondent side. I think this is it for the petitioner. See you again next time. Bye. Thank you.